We're live.
We are back at Senate Judiciary, it's January 23rd. I had a conversation with an individual who was in the room named Charles Martin. It's my understanding from what was expressed to me that Mr. Martin, through the work in his firm, has had professional experience with Mr. Dresser. And I wanted to provide him the opportunity to testify. I believe you indicated it'd be more than 10 minutes, but yeah. So you have that time, and the floor is yours.
At the Supreme Court, they have a track door. See the limit track door opens, we go into the basement as well. Or
Keep that on.
I've heard a lot of adjectives for this bracket nominee from a lot of people, but I haven't heard the word curve. And this is one of my biggest concerns. I was involved in the case. And coming back from vacation, I took a vacation during the time of the time that Mr. McDonald's situation arose. And I walked back to the office. And Andy Delaney, who represented Mr. Delaney on a completely separate issue at the time.
I'm sorry to interrupt. If you're able to, could you increase the volume of your voice?
Oh,
I'm
sorry.
personally having.
Sorry, okay. I was on vacation and I came back. I was on vacation during the time the circumstances surrounding Mr. McDowell's case came up. Andy Delaney, the partner in the firm, was representing Mr. McDowell on a civil matter. And so when he was picked up, he immediately went into action. And when I walked in the door after my vacation, he said, "I hate to tell you this, Charlie, but I just sued the president." I said, "Okay." And I then was involved in strategy and tactics and how to proceed in this case. Obviously, this was something that our firm hadn't done before, and I've been in practice for 55 years. So, as this case developed, Mr. Delaney commented on the seriousness of the case, but he also commented very much on the politeness and the courtesy shown by the nominee. However, Mr. Delaney didn't feel that he could come in and comment on this. So the responsibility fell on me. Looking at the case, the nominee had in fact done an admirable job in representing a client. But the role of an attorney, especially one that is arguing in favor of or against the liberty of an individual, is higher than just simply arguing a civil matter when the issue is property or some other matter that did not affect the liberty. The nominee testified that he took an oath to defend and protect the Constitution. The Constitution and the Fifth Amendment provide, and the 14th Amendment provides that no person shall be deprived of liberty without due process of law. That's a constitutional standard. When one goes to the position of being a Supreme Court justice, one of the things that a Supreme Court justice must have in order to be an appropriate developer of the laws for the state is courage. I want to give you some examples of courage. I was a law clerk at the Supreme Court for about 3 years. And one of the first cases that came up was before Roe versus Wade and whether or not the abortion statute was constitutional. That was a very highly hot emotional issue, even on the court, because we had one justice who was a Catholic and could not to not compromise his moral beliefs. However, the court did say that a statute that allows a woman to perform an abortion but denies her medical care is unconstitutional. That was a courageous decision. As the court went on, it made decisions such as overturning an injunction against University of Vermont to pay anti-Nixon speakers. It went on to announce that people of same sex in a relationship, so with the marriage, are entitled to marital privileges. That took courage. To say that the suppression rules do not have a good faith exception for taking issue with the United States Supreme Court. That took courage. So when you're at the Supreme Court, it's not doing your duty simply and being a good fellow. Have to have courage. So the question that I think is before the committee, after everything that was said, if the nominee is on the Supreme Court, will he have the courage? And has he shown the courage in the past? Obviously, the question is of the different alternatives he had to make. One was resignation. That would have taken courage. Question: does the nominee have the courage to be on the Supreme Court and look outside and see people watching the sign of the pro and con and make the decision? Thank you.
One moment, Mr. Martin. Mr. Martin? Oh, sorry.
Oh, I'm sorry.
I do want to give the committee to ask any questions. We've got several minutes.
That's right.
And just want to make it the same for everybody. So, committee, any questions, Mr. Martin? Sorry,
Yeah, Mr. Martin, thanks for being here. I got two quick questions. In your opinion, do you feel that due process was afforded, not your client, but your partner's client during this process?
No due process was afforded the client before the loss of liberty. That is a concern. The due process that was afforded was after the loss of liberty. And the deprivation of liberty occurred before the due process occurred.
Right. The question was, we're talking about the nominee and his involvement with this particular case. Okay, not prior to, but once your partner's client was arraigned, what's due process afforded him?
He was never arraigned.
Brought into
He
the
was
court.
never arraigned. He was simply arrested. He was simply taken into custody and locked up. There was no arraignment.
Okay, so was due process afforded that individual after the fact?
After
When the nominee's involvement, what due process afforded to the individual?
after the nominee was involved in the case, due process was afforded the individual.
Thank you. One quick question. Your opinion, did the nominee do anything unethical in this case?
No,
Thank you.
I do not challenge his ethics in one degree or another.
And so,
Anybody else? Okay, thank you very much. So we're now turning to the progressor. We have about an hour and 10 minutes or so for you. And this is the opportunity for you to respond to any written testimony and any live testimony that we've heard. And I suspect you may have some final questions as well. And so the floor is yours.
Thank you. And thank you to everybody on the committee for giving me this opportunity to respond to the letters and emails that the committee has received opposing my confirmation. I understand, I've chatted with several of your colleagues. I understand many of the senators are receiving emails from their constituents expressing similar opposition to my confirmation. And I understand that these messages largely focus on my involvement in these immigration cases, the cases of Mr. Medali and his others. At the outset, I want to emphasize that I do not question the good intentions of those who have voiced their opposition to my confirmation. I appreciate that everybody is trying to do the right thing. And I appreciate that it's very important for the senators to carefully consider the views of their constituents. I have carefully reviewed the emails and letters that the committee has posted and has shared from people who both oppose and from people who support my confirmation. The letters supporting my confirmation tend to be from people with firsthand knowledge of what I did this past year. And many are from people who know me well and who know my character. By comparison, none of the emails opposing my confirmation have been submitted by anyone with firsthand knowledge of how I conducted myself and why. And none of them have been submitted by anyone with whom I have worked or who knows me personally. I understand many of the messages have been prompted by a campaign that urged people to speak up against me as a way to fight ICE. And it's been unnerving to be reduced to an action item by groups with whom I suspect I have no quarrel. Importantly, the messages that are opposing my confirmation appear to be based on a fundamental misunderstanding of what I did in those cases and why, and the cases themselves. And I'm grateful for this opportunity to try to set the record straight. First, a lot of the criticism I've received stems from the misconceptions that the case support prosecution. And so it was within my power to halt the cases and release Ms. Oskirk and Mr. Medali. That is completely not accurate. The cases were not criminal cases. They were not prosecutions. Had they been criminal cases, I would have had authority to dismiss them. And I have, as a criminal prosecutor, proudly dismissed criminal prosecutions when the circumstances called for. And in those cases, if the defendants were in custody, they were released. But these immigration cases were nothing like that. They were civil cases. Neither I nor anyone else in the U.S. Attorney's Office had anything to do with or power to influence the State Department's decisions to revoke Mr. Medali's and Mr. Oskirk's immigration status, and the Department of Homeland Security's decisions to arrest them. We had no authority to release them. And I was gratified by Mr. Martin's statement a moment ago, recognizing that once I became involved, his client began receiving the process that Mr. Martin was doing. As I explained last week, these civil cases were important because their attorneys sued the government in order to challenge the legality of what was happening to their clients. Specifically, they filed petitions for a writ of habeas corpus, which is what a person does when they want a court to decide whether their custody is legal or not. And in the case of Ms. Oskirk, which was the first of the two cases to arrive, that case arrived in Vermont when a district court in Boston had transferred it to district court in Vermont. We had no advance notice of that case coming in. And we only learned about it after the fact. No one in our office had ever defended an immigration habeas case before. But we were told by department leadership, the Department of Justice leadership, that the case was being assigned to us. That very same weekend, the decision to assign the case to my office was made. The department started the process to fire a very well-regarded career attorney who had candidly told a judge in court that the administration had mistakenly taken Kilmar Abrego out of the country. The reason reported for this firing, and I encourage anybody who questions this to look back at the news reports from April 5 and 6 of last year. The reasons reported was that speaking the truth in court was not considered sufficiently zealous advocacy on behalf of the government. That was shocking. Career attorneys at the Justice Department, especially in the civil division, are frequently called on to handle cases that they may disagree with. But they are expected to follow legal ethics and the professional standards set out by the legal profession. And those standards require being candid with the court. They require speaking the truth in court. And recall at this time, the still relatively new administration was demonstrating a willingness to remove people from federal employment. DOGE was in full swing. Huge sectors of the federal workforce were being dismantled. So when the Oster case arrived in Vermont, federal employees were getting fired left and right. The Department of Justice had just fired a lawyer for speaking the truth in court in a high-profile immigration case just like Oster's. The attorneys and staff at the United States Attorney's Office, just as the attorneys who support the work in this committee, as well as the attorneys next door at the Attorney General's office, at the various states' attorneys and public defenders' offices around the state, are true public servants. They don't do their jobs to get rich. They do their jobs to serve the public, to contribute to the rule of law, and to reinforce the norms of ethical legal service. In the U.S. Attorney's Office, many of the AUSAs are the main breadwinners for their families and consider the U.S. Attorney's Office to be their dream job. These attorneys include single parents. At the time last spring, others whose spouse or partner had just lost their job on account of new administration's changes and policies, and several with young children who, and at least one who was expecting a child. Their work includes investigating and prosecuting fraud and civil rights violations, and some of the most heinous and complicated crimes. And as you know, as you heard today, at that time last spring, I had been thrust into the position of acting U.S. Attorney, a position that I did not ask for or pursue. People in that position typically do not take on individual cases. It's extremely rare for the leader of a U.S. Attorney's Office to assign a case to him or herself. They let the supervising attorneys figure out how to handle it. But it was obvious to me that whoever was going to stand up in court in these high-profile immigration cases, given their deeply concerning facts, was not only going to suffer from the public's inclination to incorrectly conflate a career government attorney's advocacy with the attorney's personal opinion. They were also going to become scrutinized by an administration who was willing to fire somebody for speaking the truth. Some letters that came into the committee after last week's hearings criticized me for understanding that I was trying to explain myself by saying I was just doing my job. And I regret leaving people with that impression. Because while I was doing my job, while I was doing what I felt was my duty, I actually really wasn't doing my job. Just doing my job would have been simply to hand the matter to one of the supervising attorneys and let them figure out who should take the case. But that would have been egregiously unfair to the office. Every attorney is ethically bound to speak the truth in court. And as I explained last week, I was prepared to be fired for speaking the truth rather than subjecting someone else to that pressure. So I assigned the cases to myself, and by doing so, I was not only trying to protect the office, I was also assuring myself that the cases would be handled in a professional and ethical manner, which would not necessarily have been the case if a political appointee had taken the case over. I was not going to inflame an already difficult situation. I would argue carefully and dispassionately, and thereby contribute to the process by which the difficult legal issues surrounding these cases could be resolved. In considering the messages opposing my confirmation, I request that you consider what were my choices, and you've heard a little bit about that already today. Some letters to the committee declared, and I think as Mr. Martin suggested, that I should have resigned. And Senator Ruth, you flagged that as a possibility last week during one of the hearings, and so it's certainly an option. And I thought about doing that. But as explained in the letter submitted by a 30+ year veteran of the office, resigning would have accomplished nothing. Resigning would have either saddled someone else in the office with this situation I was trying to avoid for them, or it would have caused the administration to send someone else from outside Vermont to handle the cases. And it would have done nothing to expedite the resolution of the cases of Ms. Oster or Mr. Vidal. Ironically, at the time, last spring, at the time I made the decisions to personally handle the cases, protect the office. At that time, I was strongly considering pursuing the soon-to-be open position on the Vermont Supreme Court. It was in the front of my head. And I acknowledged to a friend the weekend the Oster case came in, as I was starting to conclude it was the right thing for me to do, to decide these cases myself, that by taking these cases, I might jeopardize my prospects for that position due to public misperception. Mr. Martin suggested that the courageous thing to do would have been to resign. If my personal ambition had been my key motivation, I could have performatively resigned to make myself superficially appear like a courageous opponent of the administration. Maybe that would have looked good to the uninformed. But resigning would have accomplished nothing. Indeed, it would have been counterproductive. Or I could have sat back and watched another career attorney struggle with these tough cases. That would have been the expected and easy thing to do. But by the moral standards I hold myself to, that would have been wrong. And the third option, as suggested by a question that was put to me last week and some of the messaging, was maybe I could have shown up in court and essentially thrown the cases. Any experienced litigator will explain that would have been a violation of an attorney's duty as an advocate, and it would have been so irregular and badly received by the judges that I assure you it would have slowed the resolution of these cases down. Senator Ruth, last week, you characterized much of what the administration in DC was and has been doing as breaking things. I hope you understand that my decision to handle these cases personally was an effort to do the opposite. I was literally trying to keep things together. Not only the office I was leading, but our legal system and the role it plays as a potential check on executive power. And I'm gratified that Mr. Martin recognized a moment ago that after the lawsuits were filed and after I got involved, due process was accorded his client. I ethically and honestly advocated before the court in these highly charged cases where it was especially important that the rule of law be followed. Some of the letters to the committee declared that the way I conducted myself in litigating those cases was unethical because they believed the administration was acting unlawfully. I'm gratified that Mr. Martin disagreed with those sentiments. But it cannot be the case that in Vermont, we equate attorneys with their clients' positions. Yesterday, Chief Justice Amstoy, I was watching the hearings, pointed to Judge Pinella's confirmation as an example. And I've got another one, and it's actually, I believe, the same case that Mr. Martin was talking about. When I was speaking with one of your colleagues this week, I was asked to read the Vermont Supreme Court case from 1972, Beecham v. Leahy. And I'm certain that that's the case that Mr. Martin was referring to. I was asked to read it for its importance to the Vermont reproductive rights movement. And I did. I got home that night and I read it. And in looking at it, it was notable, who was defending the statute that made it a crime to perform an abortion. It was then State's Attorney Patrick Leahy and then Attorney General James Jeffries. No one doubts that both men were champions of abortion rights. But as distasteful as that statute must have been to them, as advocates, they sought to preserve their office's authority to prosecute someone for performing abortions. In the Supreme Court, they lost. And that's because it was not up to them, the advocates, it was up to the court. And our judicial system is based on an adversarial system that requires two sides for the judges to consider to reach the right outcome. Some of the letters questioning my ethics and how I litigated the case also misunderstand the issues that were before the court. And so with a warning, I'm just going to give you a little bit of detail about what some of those issues were. It involved immigration law. Immigration law is complex. And Congress has passed laws that are very severe for people who are non-citizens. And the Supreme Court has upheld those laws and ruled that detention in most cases does not violate the Constitution. The Supreme Court has also recognized that the executive branch may, in some cases, selectively enforce immigration laws based on the political activity of the non-citizens without violating the Constitution. Congress has also restricted which courts can review immigration decisions. And this was the principal issue I was addressing in the Ozturk and Madawi case. Whether the District of Vermont could rule on their cases at the stage it was in. It's an unsettled area of the law. It's an unsettled legal question. In fact, just last week, a federal appeals court in Philadelphia reviewing a case nearly identical to those of Mr. Madawi and Ms. Ozturk ruled that a district court should not get involved, that a federal court review of an immigration proceeding should wait until the immigration process has concluded. To be sure, other judges, including the judges here in Vermont, have interpreted the statutes differently. But that does not mean it was unethical to argue the government's position, even if I did not agree with the administration's actions. And to hopefully address for good anyone's lingering concerns about whether I acted professionally and ethically in both cases. In open court, Judge Crawford acknowledged the quality and helpfulness of the briefing that I and the other attorneys submitted. And in Ozturk, Judge Sessions complimented me and the other attorneys in open court with regard to the professionalism by which we argued the case before him. I can guarantee you that these judges would not have made those observations if they perceived the government lawyer had acted unethically or unprofessionally or misled the court as an defendant. Those emails who questioned my judgment, professionalism, and ethics for arguing on one side of the serious legal questions, appear to not understand that our legal system, our rule of law, depends on the adversarial process. And that at the end of the day, it is up to the court, not the lawyers, and not public opinion to declare what the law as passed by the legislature means. Those critics also appear to be unaware of why I put myself in that unpopular position and the risks associated with doing so. The position was so unpopular, in fact, that this week I've been the target of a threatening phone call, and I've been advised I should be on the lookout for a vehicle that matches the one registered to the call. Senator Norris, last week, you asked me whether I would have done anything different if I had to do it over again. And I hope by now you and the rest of the committee appreciate that I am a thoughtful person and I'm prepared to reconsider my previously held views. And I had not considered the question you put to me previously. And when you asked it, I just been subjected to some questions from the committee suggesting I should have done something differently. And in the past 9 days, I've thought carefully about your question and my conduct this past year. It hasn't been pleasant being treated as a symbol of this administration. and having my integrity questioned by well-meaning people, but based on an incomplete understanding of what I did and why I did it. And a misunderstanding of how our legal system operates. And despite all of that, despite the stress associated with going through this process, and despite the misperceptions and misunderstandings surrounding what I did and why, and despite all the recent criticisms, I would do it again. Because it was the right thing to do, and all the other options were unacceptable. Another point that I want to make is that on the one hand, of course, this is about me, but it's not just about me. I assure you, there are public servants who are working in the federal executive branch, the VA, the Forest Service, the Department of Agriculture, the Department of Justice, Homeland Security, many of whom are your constituents, who, like I was, are trying to keep things together. They're trying to reinforce and continue the norms of honest and ethical government service. They're trying to keep the country within the guardrails. And we want those people working for the government. If you or your colleagues vote against my confirmation based upon my efforts to protect the people under my responsibility and for my efforts to try to keep things from breaking further, and for my efforts to reinforce the norms and institutions that have served the country and the state for generations, I suggest that such a vote would be a disservice to the public servants who you want working in the government right now. I also want to be clear, I appreciate your dilemma. People who don't know me and who don't understand what I did and why have been sending you emails opposing my confirmation. They are your constituents, and their views warrant careful consideration. And I don't doubt their motives or intentions for a moment. And as Ms. Nolan recognized yesterday, them weighing in is part of what makes Vermont. On the other side of the ledger, people who do know me, people who have firsthand knowledge of what I did and why, strongly support my confirmation. I hope you understand that those that vote incorrectly conflate my efforts to protect the people I care about and to be a responsible advocate, contributing to the administration of due process. That they mistakenly conflate that with me being politically affiliated with the administration, and being unsympathetic to the treatment of Ms. Osterg and Mr. Medali. That perception is incorrect. Rather, I suggest my conduct this past year demonstrates that I am prepared to be unpopular. I'm prepared to take on extra work and to subject myself to risk if that is the cost of protecting and serving the people I am responsible for. I suggest those are among the traits you want in a Supreme Court justice. Yesterday, Chief Justice Hammerstone implored you to consider a candidate's integrity, hard work, compassion, common sense, and the importance he or she places on community, and the capacity to make an unpopular choice. As referenced yesterday, those of us who are old enough will remember the Take Back Vermont signs that were everywhere after the Baker decision. To many Vermonters, that decision was very unpopular, but the court was prepared to do the unpopular and made legal history. I believe my work this past year demonstrates that I will put my belief in the legal system and our Constitution over the over my self-interest or my popularity, such as it is, and I will put in the work to serve the public. I request that you and your colleagues base your votes not on the misunderstandings that have fueled the emails opposing my confirmation, or the number of such emails, but rather on an accurate understanding of what I did this past year and for the previous 30 years as a Vermont lawyer. During that time, I have been subject to the authority of judges. I have lost and won plenty of cases, civil and criminal, in state court and federal, trials and appeals. Some of the letters the committee has received contend that I lack state court experience. That's incorrect. I suspect I am one of the very small number of Vermont lawyers who have tried multiple jury trials in both federal and state court, and who has argued before both the Vermont Supreme Court and the Federal Appeals Court, and who has represented a criminal defendant in both state and federal court. Moreover, as referenced last week, much of the work that I did in the U.S. Attorney's Office was extremely intertwined with state law. By way of just one example, several years ago, I investigated and prosecuted several of the executives of what is now known as UVM Medical Center. Back then, it was called Fletcher Allen. The crux of their crime was making false statements to the state, to Vermont's healthcare regulator, then known as VISHCA. So while it was a federal offense, the prosecution vindicated the importance of abiding by Vermont state law. I watched Ms. Nolan's testimony yesterday. I have at least as much experience as her in Vermont State Court, like her, triggered by her list of courthouses that she had appeared in. I went down my own list. I recall appearing in state courts across the state, from Newfane and Brattleboro to Woodstock to Chelsea, Montpelier, Barrie, Hyde Park, Burlington, as well as the Vermont Supreme Court. And there should be no doubt, based on my record, of my skills as a legal researcher and writer. My career has taught me that our legal system requires lawyers and judges to be faithful to the law and to honor the litigants that come before them by treating them with respect and dignity. To hold the government to the highest standards and to promote liberty by being a counterbalance to the imbalance of power that permeate in our law. As I observed to some of you and your colleagues already, in my view, the most important reader of the judicial opinion is the losing side. If the court does not demonstrate that it has carefully and respectfully considered their arguments, the system will lose its legitimacy. I have carefully considered the reasons behind the emails opposing my confirmation. And they're wrong. They're based on misunderstandings. I suggest Vermont wants an associate justice who has demonstrated that he or she is willing to take on the extra work, subject him or herself to personal risk if necessary, and to do the unpopular thing if it is necessary to honor the rule of law and maintain our traditions of individual liberty. Thank you.
Thank you, Mr. Treasurer. I have a few questions to start. One point that's been raised a few times is regarding public misperception, public misunderstanding, and I understand that. I've been, over the past 2 weeks, as I've spent the time going through the pleadings and talking to other attorneys who are smarter than me, I have come to understand the rationalization and the procedure and the work that you've done, and where that butts up against my job here as a senator is the many emails I'm receiving, which you are aware of, and I know that all the other senators are aware of. And I don't expect, frankly, any constituent almost any constituent to have a firm understanding of complexities and the nuances of your job and what happens in federal district court and immigration court and so on. But the challenge for me is what I'm interpreting from all of these messages, from all of these constituents, is the underlying message that any involvement whatsoever, with regardless of what the justification or rationalization may be, any involvement with the current Trump government's policies on immigration is essentially the end of the road. It's what I'm getting from constituents. And so the challenge that I'm facing is rationalizing, figuring out how to represent the message that they are sending, while also coming to an understanding of why and how you did the job that you did. And I suppose I don't have a question in all of that. It's just a comment that I think this is one of the hardest decisions that I've had to face. I haven't been here for very long, but at least at this point, this is the hardest decisions that I've had to face. The one question actually that I do have that'll go to, switching gears a little bit. We did receive one letter from a retired judge, Judge Wesley, who was critical of you. And just a disclaimer, Judge Wesley is a constituent of mine. The letter came unsolicited. I've known Judge Wesley for quite a long time. My encounters with him were when I was a state trooper, and I appeared in front of him that capacity a number of times. And I hold great respect, Judge Wesley. And the letter that he sent was very powerful. I was wondering if you could respond to that letter.
Yes, I spent a lot of time with that letter. That letter reflects a misunderstanding of what the case was about. It reflects and it misstates the role of an advocate. I think that letter is a symptom of how passionately people feel about the Trump administration, as Chief Justice Amsberg recognized yesterday. That letter states almost explicitly that because Judge Sessions and Judge Crawford decided that Ms. Osterk and Mr. Badawi should be released, I was unethical in litigating the case from the get-go. Because of the result, because I was on the losing side as an advocate, I was unethical. That's the logic behind the statement. That statement is wrong as a matter of how the legal system works, as my comments earlier today tried to explain. And it also misapprehends how close the legal questions are in these cases, as last week's decision from Philadelphia indicates. It also, I believe, a verb he uses in his letter is he claims I could have discharged the case, which I think reflects the commonly held misperception that it was a case I was prosecuting, that I had authority over, that I actually could have done something to cause their release. So it's based on an incorrect understanding of what the case was about. It's based on an incorrect understanding of what my role and authority was in the case. And it frankly misstates what the role of an advocate is and should be in our adversarial system. I took a very hard look at that case because he's a retired gun. Or that letter rather. I'll note that another retired judge, a judge before whom I appeared on a regular basis, Judge Sean Conway, has written a letter supporting my confirmation. And I would urge the court to consider the letter from a judge before whom I've appeared on a regular basis over the letter from a judge who, by virtue of his letter, demonstrates he's not familiar with the details of the case. Another example, I believe Judge Wesley's letter declares I have no state court experience. And I have a lot of state court experience, and Judge Wesley's statement in that letter, I think, displays that he had not read my application and was not familiar with my application, nor was he familiar with my qualifications. I don't begrudge him writing that letter at all. Like anybody else who's weighing in, it's their prerogative, and the more perspectives you hear from, the better. And I'm glad you're carefully considering it. And just like everybody else who's written in, I don't question anybody's intentions. Everybody's trying to do the right thing. And I hope, as the senators are trying to do the right thing, they keep their eye on the signal, not the noise, as you mentioned yesterday, Senator Thomas. What did I do And why did I do it? People might disagree with, maybe I should have resigned. I hope I took that on earlier today, or maybe I should have assigned it to somebody else or done any of these other lousy options. I don't think anybody can. Well, I hope that everybody understands at a minimum, the choice I made was reasonable. And it was an effort to be principled, and it was an effort to protect the community. And it was a hard choice. It was a hard choice. Mr. Martin said he hadn't heard anybody use the word courage. And, people choose their own adjectives to describe what I was doing. Part of me was scared of taking those cases on. But I was trying to do the right thing. I knew it was going to be unpopular, and I knew it was going to be subject to scrutiny from multiple sides. And I suggest that what I did was a sign of courage, even if you disagree with what I did. I was putting myself in an unpopular position because I was trying to do the right thing.
Thank you. All I have for now. Any concern with
Thank you again. And I know this is a very emotional process that gets to, in a similar way for us when we are public figures, it gets to misperceptions perhaps about oneself, feels very personal, very insulting. I just want to go to three different things. First, about the email campaign. I understand that for somebody outside the State House, it may seem that receiving 500 or 1,000 emails must determine our positions. We are all very used to receiving hundreds of emails. Speaking only for myself, I will say that I note them, I count them mentally, because there's some value in that data, but they don't determine my vote. Ultimately, I voted to confirm Secretary Saunders last year. It was a very controversial nomination. And I would say the majority of people in my district did not understand my vote to confirm them. But I believe that the governor, having been duly elected, especially for as long as he has, by the margins that he's shown, he has the right to nominate who he wants. And in the absence of something that I am truly troubled by, I will push a nomination for. I am troubled, as you understand, at this time by, in particular, the Medallic case, and that comes from, in part, our assistant majority leader was there when he was taken into custody. And it became a case that I was involved in from that point, from the outside, from the State House perspective. But I went with Senator White to an event at a church in her district. Hundreds of people there agreed and were following that arrest, and with real fear about where the country was headed. They felt that there was a rent in their community. And so then comes a candidate for the Supreme Court who was in part acting on behalf of the Justice Department in that case. So I tried to get at this before, and I think this goes under the heading of people of good intent and good heart can see things completely differently. So you mentioned the pressure from Justice Department leadership in terms of how these cases were being handled. You also said it was extremely rare for you to take this. And I don't question, you're the expert on what is rare or what is not rare. But I think about how that would look to the people in the Justice Department. So they are putting pressure, and now in an extremely rare move, the head of the office takes on the case and attempts to defend them. That might seem like zealous advocacy, on their part. In other words, they're not experiencing resistance. They in fact have a rare instance where the head of the office takes it on, and according to what we've heard, does a fine job with that. So for somebody who's in that church in Windsor County, they see what you're doing as advocacy, maybe above and beyond what you need. Extremely rare, which your phrase, from your point of view and from the witnesses that have come forward for you, it's heroism for you to have done that extremely rare move, moving the administration's case in the narrow context that we have. So, so for me, it's, and I hate to keep referring back to Mr. Perella's statement, beginning with Martin Luther King. That is an attempt to report, not just to say this wasn't a bad thing. It's to invoke Martin Luther King. This was, you know, a huge act of courage. I have a hard time seeing it that way. I can understand that it would be a difficult decision and that you might have had good motives. It does not strike me as, you know, Martin Luther King Jr. level decision to take the case yourself. So I find myself mostly challenged by that question at this moment in our history with this administration. How much cooperation with, you know, what is to me a metastasizing immigration operation that is slowly becoming a domestic, you know, force, ICE that is. And the president is now talking about sending in active duty troops in the outlands. My question is, what constitutes, if not courage and thought for the situation, how it exceeds normalcy?
So there's a lot in your comment, in your question, and I have a lot of thoughts in my head to respond. Focusing on very recent activities by this administration, what's going on in Minnesota, and it looks like it's going to be in Maine soon. And it's the courts that are providing some check on it. And the courts cannot do that unless there are advocates on both sides in the courtroom. I don't know the intricacies of the lawsuits or the legal proceedings in those areas, but I read the headlines that courts have ordered or put limitations on what the administration can do. In order for the court to be able to be an effective check on executive power under our rule of law, under our system of government, requires an advocate to stand up in court ethically and take a position he or she does not agree with, presumably. That's not easy to do. Nobody enjoys doing that as a lawyer. But is it necessary to be done, just like it's necessary for a criminal defense lawyer to do the same thing, for the system to work? And if you don't have lawyers of good faith doing that, the system will stop. The system will not work. So I appreciate I appreciate we see things differently, and I suspect we see things. I suspect we're more aligned than different in how we see things. But I also appreciate the optics of what it looks like, what it looked like for me to be standing up in court representing the government in the Madawi case in Phillipsburg. And you know, that's your dilemma. It's don't get me wrong, I'm proud of what I did, but it's also to a certain extent my misfortune right now. So my first reaction was, you need lawyers to do that. You need lawyers to do that on both sides. And I was doing that in these cases. You mentioned, you know, Mr. Madawi's arrest, to remind on the committee. I had nothing to do with his arrest, nothing to do with it. When Mr. Martin's law partner reached out the afternoon of his arrest to let me know that this case they had just filed this case and that the court had just issued called a temporary restraining order. It's an immediate order that's issued before you hear from the other side, requiring that Mr. Madawi be kept in Vermont. And I got a copy of that. I went to work reaching out to the people I knew at Homeland Security to make sure that they were aware of that order and that it was going to be abided by. I performed a similar role in the Oster case after Judge Sessions ordered her released from Louisiana, and there was a delay in that process. Eventually, Judge Sessions heard from the lawyers late in the day. That day, you can see this on the docket, and issued a short written order confirming what he had set up for the bench earlier that day, and that got his Oster released. And I played a material role in that order. You need good lawyers, ethical lawyers, taking on these cases for our system of government to work. I met with Senator White, and I was prepared to explain myself like I've been explaining this room. And before I had a chance to do that, she wanted me to hear what her community had suffered on account of the Madawi case. And she wanted me to hear it, and I did. And I am aware of the trauma of Mr. Madawi's circumstance, of the trauma the community suffered on account of the way Mr. Madawi was treated. I'm aware of how the entire state has reacted to it, and beyond that, I recognize he was showing up for his final citizenship interview when he was arrested. I am well aware of the details of what happened to him, and I've spent a lot of time thinking about it because of my role in this case, and I appreciate the trauma. I appreciate the misfortune that it was for Mr. Madawi, and I appreciate the trauma that it inflicted on the community, and I listened to what Senator White had to say about that. So I guess I want you to know that I have a sense. I wasn't in the church meeting that you were at, but I have a sense for what it was like, and for what. And I read the 200 letters that were submitted on his behalf as part of my role as an advocate. So I'm aware of the evidence of what it was like for that community and how many people supported it. And kind of like what we talked last week, I'm not taking credit for his release. The court did that. What I'm taking credit for is facilitating the administration of due process. And playing a role in my life in that.
Well, thank you for meeting with Senator White. I consider it.
Just a quick time check. There's a little over 15 minutes left. 17 minutes. Any other questions?
I have quite a few. I'm not sure that I'll be fit 15 minutes. My first question is actually for you, and is that every email we've gotten, has that been put into public testimony or only the ones that explicitly asked for that?
No, not every single one. There are many form emails. Example of the form emails has been posted, but not every single one. The one-liners that just say vote no without any additional substance. Those aren't updated, or those aren't put on the committee page. The ones in which people request that they are updated or put on the committee page, they are put on the committee page. And I have had an away message on my email, so that anybody who sends an email with what could be received as written testimony, my away message says, if you have written testimony, that you'd like updated, send it in a PDF to our committee assistant.
Okay, that is helpful. There has been from multiple witnesses, a characterization of the emails as form emails, and all from people who don't know or have never worked or misunderstand the law. And the reason I ask is because I have seen a number of emails actually that have explicitly laid out how folks do know you that are not support. And I also previously pointed to people who I have spoken to who have experience, are not supportive, but are afraid to go on the record. And I guess I wonder, one, have you seen those emails? And I'm hesitant to name names if they don't want them in the record, given the level of concern that has been expressed from some people. But it's in the characterization of all of the emails being form emails coming from people who've never met you. That is not everything I've seen. And so I'm wondering if you have seen any of
So
those.
the emails I have seen are the emails that have been posted on the committee's website. And I haven't counted them. I suspect they're in excess of 20. The ones opposing me, there are several in favor of me. And I appreciate that they don't strike me as form emails, that people have taken the time to, like Judge Wesley did, to share their thoughts. I have not seen an email from anybody with whom I've worked. I've not seen an email from anybody who knows me personally. And Senator, it troubles me greatly to hear that somebody would fear retribution if they had something negative to say about me. There's a lot of people whose names are in the record on account of the committee's website who have opposed my confirmation. And I mean, so, and Senator Booth, you had suggested that maybe what they feared was some sort of vindictive, politically motivated prosecution because of the times we're in. I understood it.
Or in part, the other thing is that this president has been overt about trying to inflame loyalists around the country, and those people reach out to anybody who raises their head up and attempt to chill their speech.
So I'm not sure at this point in time. I don't know how the administration would be thinking about me if they're thinking about me at all. I'm not sure that they would necessarily be thinking about me favorably, given some of my statements right now. That's one thought. I can guarantee you, I'm not in the office anymore, but I can guarantee you, based upon my personal knowledge of people in the U.S. Attorney's office, that they would have resigned before they were asked to initiate a politically motivated prosecution. I would have done that when I was there, and I know the leadership in the office right now, and they would do the same thing. It breaks my heart that somebody would fear retribution or saying something negative about me. I hope what you have heard about me gives you some comfort that I would certainly not initiate any. It's so contrary to the way I think of things. It would break my heart if somebody actually thought on account of something I would do, they might face retribution. It's not fun hearing people criticize me, but it's healthy. It's good. And if I have weaknesses that haven't already been aired, I'm not going to be happy to hear them, but it's going to be good for me to hear them. And so if there's some way you can share the comments or concerns that you've heard, whether to protect the sources or not, I request that you do, and I would love to have the chance to sit down and try to address them with you one-on-one or in some other form.
And I can interject and just respond to part of what you're saying. So if there are folks who have testimony that they want to provide, written testimony, I guess it's just generally, you can submit that testimony to our committee assistant, Emery. His email is on our committee page.
I appreciate that. And I'm glad to know you haven't seen them, the emails that I'm talking about, because when I hear multiple people say this is the only thing coming in, people just don't understand. Yet I'm looking at something different. I want to make sure that we're actually looking at different things. And so I do appreciate that. And certainly will circle back to the folks, because I want to be clear, it's not a person. It's been multiple people who I've asked to come put what they have to say on the record who have said I can't do that. And I don't think, I think it's a confluence of things. I don't think all of it is simply, I don't trust people. I think it's, I don't trust the system. I don't think it's just like, I think there's a lot of things coming together right now, making people very hesitant. And I'm happy to think through what the solution may be. Last week, I asked if people could testify anonymously. And that was not something that we are moving forward with. So I am committed to figuring out a way, if there is a way. And I will also say that some of those statements have asserted that they do think you're a nice guy, and that's not enough. And so I'll go through the emails that I've seen that it's clear you have not, and I will call back the folks that I've spoken to and see if any of them feel comfortable, or if there's a way they feel comfortable in bringing those stories forward.
And if they want to stay out, I mean, if they want to be public, that's their right, obviously. But if they want to stay out of the public eye, you know, you and I can sit, if you could, I hope you would trust me that I would treat them privately. And you and I could go over them, and we could talk through the concerns. And I would welcome the chance to sit down with you and try to address the concerns you're having.
I appreciate that. I am wondering how many trials you have litigated in the state courts.
Jury trials 3. And then at least 2 other hearings that I recall where I handled witness testimony. One was in family court in Barrie, and the other, also multiple hearings before the Public Service Board, where witness testimony is put on, witnesses were cross-examined. Those are trial-like, but they're not technically trials, they're hearings, they're administrative hearings. And then criminal change of plea that I can recall. A lot of them were sort of ministerial status type hearings. But your question was trials. So 3 jury trials and lots of contested hearings in administrative tribunals.
I'm wondering about your role in a press conference in September of 2025. I believe it was in Florida, and there's some quotes of you being fairly supportive of Attorney General Bonding, and I'm just curious.
Yeah, so it's on YouTube. It's out there. I can tell you what. I'll tell you, if you don't mind, I'll tell you it from my perspective, which I think is probably going to be most responsive. So I believe that was in early September, if I recall. Okay, so far so good. The week before, my office charged a case involving a woman who was involved in an alien smuggling operation. I appreciate alien as a charged term, but that's also a statutory term. Who was charging the non-citizens she was smuggling into the country exorbitant fees, and among the individuals she was smuggling was at least one child who was secreted in the back of her vehicle next to luggage. My recollection is the child was, well, I should be careful because I don't want to make a public statement about something that's not in the public domain. The Department of Justice was emphasizing, and I think it was a good thing, charging cases where children were being subject to smuggling operations, and wanted to feature such a case from the northern border. Most of those cases come in from the southern. I was in California visiting my 88-year-old mother, and on Tuesday I got a message from somebody at Maine Justice, basically ordering me to be in Tampa on Thursday. If you read the text, it wouldn't look like an order. It's like, hey, I know you're out there with visiting family. Really appreciate you being there. Sorry for the inconvenience. But it was a message I could not say no to. I felt I was proud of the work the office did charging that case. It was a case very worthy of being charged. I didn't know what was going to be expected of me at the press conference. I knew there was going to be, I didn't know if I was going to be called on to speak or where I was going to stand. But I prepared remarks just in case. And it turns out that there was the politically appointed United States attorney from Houston and from El Paso, and then the host politically appointed U.S. attorney in Tampa who was also there. I was the only apolitical guy in the room. I went out to the and I took a red-eye flight out. I bought a suit on vacation so that I could look the part. I took a red-eye flight out, got to the office where the conference was happening, and shortly before, I think it was a 3 o'clock start time, the Attorney General arrived, shook people's hands. You must be from Vermont. Vermont. Well, let's get going. We went into the news conference, and shortly before we got into the room, the team was told, okay, here's where people are going to sit, and here are the people who are going to give remarks. So I'm glad I had the remarks prepared. The remarks I gave did thank the Attorney General for bringing attention to the good work of the Vermont law enforcement community and bringing this case. I took the opportunity, which I've come to appreciate since I've been in government management. One of the best things you can do is recognize the good work of the people you're supervising and working with. And this was a big stage. The speakers before me were criticizing the policies of the previous administration, and they were making my eye inappropriate characterizations of the people who've been charged. It seemed like an irresponsible thing for a prosecutor to do before a case had been adjudicated. But finally adjudicated, you need to be very careful not to prejudice anybody who's looking at the case or learning about the case in the public eye. So when I started my remarks, I thanked the Attorney General for bringing attention to the good work of the Vermont law enforcement community. I then explained to the public what the status of the case was, that the defendant had just been recently arrested, the potential sentence she was facing. And then one of the things I'm most proud about that press conference, I took the opportunity to recognize by name the work of the AUSAs who put the work in to charge the case. Nobody else in their remarks recognized the work of by name of the people who had done that. And you know, they also come from bigger offices. Maybe they don't know that people put it in it. But I took advantage of the opportunity to bring attention to the good work that my office was doing and that the Vermont law enforcement community was doing in that case. In a context where, I mean, I could have said no, but that wasn't worth getting fired over. That was that. And then I got on a flight back and I went back to my mom's house and was there. I was only gone with that.
Quick logistical thing here. The reason I was texting, we will be going to 12 so that other senators can also have an opportunity to ask questions. Senator Ruth, I understand will be going.
I apologize. I'm going to be on the floor at 11:30. So I'll leave now, but I believe the committee's going to continue.
And Judge Oyang's confirmation will be on Tuesday. So
Rather than postpone,
than,
thanks. Senator Polowski has more questions for us.
and perhaps officers.
Thanks.
I absolutely appreciate the and this administration had used individual instances of real issues to conflate that all immigrants are dangerous. Did it not occur to you that you being there might legitimize their claims that immigrants are dangerous?
I was focused on the case we charged. I abhor this suggestion that all non-citizens are dangerous. It's factually inaccurate. And I think it's ugly rhetoric. And I'm trying to remember the press conference. I don't recall as I was on the podium hearing, and then again, it was in my own head. But no, short answer is no. I mean, one reason why those cases are important to charge, in my opinion, is because the smugglers are exploiting the non-citizens, even though they're entering the country illegally, who are just trying to make a better life. And they're being charged outrageous sums of money. And then sometimes they're delivered to a place in, they become indentured to the group. And they're being egregiously exploited, and that's wrong on a million different levels.
No, I agree.
And I'm sensitive to that.
I agree wholeheartedly, and I'm not questioning at all the decision to charge
Yeah,
this case.
no, I understand.
And certainly in a previous lifetime worked with our Vermont Human Trafficking
Yeah.
Task Force as a social worker. And what my question is, this administration, and frankly, it hasn't only happened in this administration, picks and chooses egregious cases to paint a larger picture. And my concern is that this is a perfect example of a truly egregious case where we can bring everyone together and say, look at this egregious case. This is what's happening everywhere, every border crossing. And that concerns me that it didn't cross your mind that that might be what the administration was doing in this instance.
Yeah, I mean, nobody shared with me the remarks that other people were giving in advance, so I didn't have any advance notice. Honestly, I was focused on what I was supposed to say, what I wanted to say, not what I was supposed to say, what I wanted to say about the work of the Vermont law enforcement community in my office.
What do you think the importance is of public trust in our courts?
It's very important.
Absolutely. And so I've heard that a lot of the outreach is coming from people who may not be attorneys or may not understand, but they are public.
Yeah.
And what they're expressing is that they don't trust.
Yeah, that's sad on lots of levels, personally. But I get the optics. I get the optics. I stood up in court in those cases, for the reasons I've explained. But what I hope, if any of your constituents perceive me to be personally aligned with the administration, I hope I've been able to disabuse them of that. I hope I've been able to disabuse any of your colleagues of that concern. And I'm hopeful that when you decide whether to vote or not for confirmation, you make that vote based on the understanding of what I did, not how it's perceived by people who don't understand it as well.
Any other questions or comments? I think the question.
I don't know, question more than a comment. I don't know what dance, so it'll be a question or a comment, but, I can relate to the constituent emails that we got because I, for one, didn't know the intricacies of federal law and how it interplays with the job that you've done. And when I really think about it, it's been brought up a lot. You see it across the country about, well, you can just resign. And when I think through that and think about it more, pardon me, with the current administration at the top, maybe that's what they want, so they can put their folks in place. Who knows? I can't talk to the motives of the administration. But when I think about the job that's before you and that you've done previously, and what I would look for in a Supreme Court justice is when it gets hard to do the job, I don't want you to run away. I don't want you to resign. Here in the legislature, when a job gets stuck for us, we tend to kick it to a task force or a report or a study or something like that. The Supreme Court doesn't have that option. And, I appreciate you staying in and working for the people that were under you. And this whole process has been eye-opening to me because I didn't fully understand what your position was before and how that all works. So it really brought my eyes and helped settle my thoughts and concerns that have been brought up by these emails of our constituents, not just in my town, but across the state. So I appreciate all the folks that have come in and have been able to interpret that better for me, who's not an attorney. I'm not involved in the justice system. So I think
I appreciate your comment. I appreciate that it's a not very well, it's a complicated area of the law. And so it's difficult to understand even if you are a lawyer. So
Mr. Drescher, I have one last question. I think it's gonna be a yes or no, or perhaps I may not be able to answer it. Those are the rules of judicial conduct. It was around April 4th. I believe it was a Mont Digger article. Governor Scott said that the country should be ashamed in response to ICE's actions. And are you able to share whether you agree with the governor's statement or disagree, or are you able to answer that question?
I have a very, I have an answer. What I'm struggling with is whether giving it would be the potential breach of the code of judicial conduct that applies to judicial candidates. So I will share with you my thinking in real time as I'm trying to. So as I understand the way the code operates, a judicial candidate should not make a comment that would tip his or her hand on a matter that might come before the court. Whether the conduct of ICE in April of last year might come before the court. I think there's a sufficient possibility that somebody could get sued over something that happened. And because of that, and based upon my understanding of the code, I don't think I can answer that question. For that reason.
Understood. All right. Thank you. I think we all have a lot to think about. We'll be voting next week, either Thursday or Friday. And we'll be made aware of that once we post the agenda.
Okay, I appreciate that. And Senator, if you don't mind, I'll email you my contact information, and then we can, if you'd like to meet in person or over the phone or in any context, I'd be happy to. Thank you.
Thanks.